Good morning. Today we are going to continue again the previous lecture, that is on person and personality and the status of different entities. Okay, we have seen the status of dead, we have seen the status of unborn person also, unborn child also. Okay, now we will see today the legal status of animals, which are called as lower animals. We human beings are also animals, but we are higher animal because we are having more reasoning power. Therefore, the animals are called as lower animals, domestic animals, the pets and all, wild animals. Those will be called as animals. Okay, living human beings, the other animals. We are going to see the status of those animals. Law does not recognize beasts or lower animals as persons, as they are having no natural rights or legal rights. What Salmon says that animals are mere objects, but they are never subjects. Means they are not subject of rights. Beasts and animals are incapable of legal rights and duties. Their interests are not recognized by law. This is the main status of animals. However, in legal history or the archaic code, penal code or law contains provisions where punishments were given to animals if they were guilty of homicide and all. Means animals were responsible. Like one case is there which occurred in Germany, that a crow was liable for nuisance because he was doing nuisance to a person. So he had filed a case and the crow was held responsible. Means archaic criminal law states that animals were having the status, they were liable. Okay, they were liable if they do any wrong. What Sutherland says in Sutherland's book Principle of Criminology, an interesting trial he has mentioned which occurred in 1519. The trial was against rats. They were accused of what? Ravaging the field of a farmer. The farmer had filed a case against those rats that they have ravaged his farm. From the rat's side, a contention was made that the rats, when they make hole, they make the land fertile. Upside down the sand becomes, therefore it is made fertile. Therefore they are helping the farmer. But the court held them liable because they have ravaged the field. However, though their defense was rejected, punishment was given by the judge. And what was the punishment? Death penalty. And while executing the death penalty, the court has clearly mentioned care should be taken from dogs and cats. Lenient treatment should be given to pregnant rats or small rats. Such a type of case or such a type of statement or an interesting trial Sutherland has mentioned. Means the archaic code was recognizing the position of animals. Now we'll see the modern law. What modern law says? Modern law is saying that animals are not having any rights and duties. However, the master, the owner of those animal, he will be liable if his domestic, his pet does some wrong, does some damage. Means in modern law, or the modern law is making liable the master for wrong caused by their pets, not by vicarious liability, but by implied negligence. Law protects the animals also. We are having so many laws. Wildlife Protection Act is there. Prevention of cruelty towards animal is there. These laws are there which are protecting the animals. Means we have made laws to protect the animals. We have provisions of mischief and all in penal code. Therefore we are protecting the animal. And here what Salmon says, we are protecting the animals by a way that it is our duty towards the animal, not towards the animal. It is a duties towards the whole society. Duties towards animals are in fact duties towards the society itself. This is a statement of Salmon. It is a duty of the society to protect the interest of the animals. Therefore we are having sanctuaries, national parks, isn't it? So today in modern law, animals are recognized, they are protected, their master will be liable for negligence and all. But it is made clear the animals are not having any rights and duties. Okay, this is the legal status of animals. Now we'll see the legal status of idol and mosque. Judicially, it is been held that an idol is a juristic person. Therefore, it can hold property. It has to pay the tax if they don't use their income for charity purposes. Therefore, idol is a juristic person, and the pujari or the devasthan committee who is there, the public trust is there for these religious institutions. They are made liable for their wrongs. They are bound to pay the tax. They are bound to keep the accounts. They are bound to audit and all. They come under the charity commissioner. Okay, they come under the public trust. Therefore, clearly it is been held that idol is a juristic person. Now we'll see the position of a mosque, but mosque is not a legal person. In Maula Baksh versus Hafizuddin, a case in 1925, it was held that mosque is a legal person, but it was overruled by another case, Masjid Shahid Jang case in 1940. It was held that a mosque is not a legal person. Therefore, it is a position now that mosque is not a juristic person. But in Sikh, the Guru Granth Sahib is considered to be a legal person. In Sikhs, they don't follow certain things, or they are having their own rules and regulations. The Sikhs worship their Guru. The book which is there, the pious book which is there, which is called as Guru Granth Sahib, it is being held therefore as a juristic person. Idol worship is not there in Sikh religion. They rely, they believe, they have faith in Guru Granth Sahib only, and in law it is considered that Guru Granth Sahib is a juristic person. It is a legal person. Okay, now we'll see the legal position of a minor, a drunkard, and a lunatic. Okay, now what will be the position of these three in contract? So in contract, what is there? Minor is not liable for anything because his contract is altogether void. A major person should not enter into contract with a minor because minor's contract is void ab initio. So it is a good position for the minor then, if you see from the viewpoint of a minor. Therefore, contract law is protecting a minor. They are telling that you are incapacitated. Competency to contract is there. In competency to contract, it is clearly mentioned the person should be major, the person should be sound mind, and the person should not be disqualified by law. Therefore, a minor cannot enter into a contract. An unsound mind person cannot enter into contract. If they enter into, that contract is void. Okay. Now, this minor and lunatic I told you in contract. Then a drunkard. What about drunkard? A drunkard also does not understand what are the terms and conditions of a contract. Therefore, when he is drunk and he enters into a contract, that contract is completely void. But when he becomes sober and then he enters into a contract, he understands everything, then the contract is valid. Okay. Therefore, a contract entered into by a minor, a drunkard, and a lunatic are void. Okay, this is the position of these three in contract. Now we'll see in penal law. In penal law, a minor is, like you can say, it is stated that a child below 7 years of age is not liable. Nothing is an offense. It is done by a child below 7 years of age. Okay, but above 7 years of age, but below 12 years of age, if a child is there and he understands everything, he understands what he is doing, whether it is contrary to law or not, whether he is doing some wrongful act, then such a person will be liable. Such a minor who is between 7 to 12, he will be liable. Okay, this is the position of a minor in criminal law. What about drunkard? Now again drunkard. If a person is voluntarily drunk, then he will be liable. But if he is involuntary drunk, then he will not be liable. Because the involuntary drunk person does not understand what he is doing, what are the consequences, whether he is doing right or wrong. Therefore, an involuntary drunk person is not liable. Nothing is an offense. It is done by a person who, because of the drunkenness, he is in a position, involuntary drunkenness, against his will, without his consent. then nothing is an offense. Okay, this is the position of a drunkard. Now lunatic. If a person is an unsound mind, then he does not understand. Again the same thing, the consequences, the nature of the act, whether it is right or wrong, contrary to law or not. So nothing is an offense. This is the position of a drunkard, a minor and a lunatic in penal law. Okay, now we'll see in tort law. What about torts? Now the position of a tort in a minor is liable in tort. If a minor does a tort, he is liable. The compensation can be recovered from his property. But where the tort requires mental element, then the minor is not liable. That is, for defamation and all, the minor will not be liable. But the minor will be liable for assault and all. Okay, because in assault, intention is not required. The same position is of the drunkard. The drunkard is liable. The compensation can be recovered from his property. Same position is of the lunatic. An unsound mind person, if he commits a tort, his property is liable. Means he is liable. Infancy and all these things are not a good defense in tort. But wherever mental element is essential, there the unsound mind person will not be liable. He will be exempted. His property will be exempted. His property will not be liable because he is not having any intention. He does not know right and wrong because he is unsound. So this is a position of minor, drunkard and unsound in contract, in penal laws, it means in criminal laws and in tort. Okay, bye bye. See you in the next video.